Go forth, mind, body, and spirit. We're at suprema.justia.com. We'll continue the RICO cases for the syllabus. We're at United States versus Turkette, 452 U.S. 5786, 1981. Number 80-808. Argued 1981. Decide 1981. Syllabus. Chapter 96 of Title 18 of the United States Code, entitled Racketeering, Influence, and Corrupt Organizations, RICO, was added to Title 18 by the Organized Crime Control Act of 1970. Now, Title 18 U.S.C. 1962C, which is part of RICO, makes it unlawful for any persons employed or associated with any enterprise engaged in or the activities of which affect interstate or foreign commerce due to conduct or participate directly or indirectly in the conduct of such enterprises' affairs through a pattern of racketeering activity or collection of unlawful debt. The term enterprise is defined in 18 U.S.C. and 1961-4 as including any individual, partnership, corporation, association, or other legal entity, and any union or group of individuals associated in the fact, although not a legal entity. An indictment charged responded others with inter alia a conspiracy to violate 1962C. The indictment describes the enterprise in a question, a group of individuals associated in the fact, the purpose of engaging in certain specified criminal activity. Respondent was convicted to federal district court, but the Court of Appeals reversed the grounds of the RICO was intended solely to protect legitimate business enterprise from infiltration by racketeers, and does not make it criminal to participate in association with which performs only illegal acts and had not infiltrated or attempted to infiltrate a legitimate enterprise. Held, the term enterprise, as used in RICO, encompasses both legitimate and illegitimate enterprises. A. Neither the language or structure of RICO limits its applications of legitimate enterprises on its face. The definition of enterprise in 1961-4 appears to include both legitimate and illegitimate enterprises within its scope. The section describes two separate categories of associations that come with the purview of an enterprise. The first encompassing organization in such corporations, partnerships, and legal entities, and the second covering any union or group of individuals associated with in the fact, although not a legal entity. The second category is not more generalized description of the first, and hence the rule of ejusdem generis cannot be properly applied or to hold. Next, that the secondary category should be limited by the specific examples enumerated in the first. B. With respect to 1962C, an enterprise is not a pattern of racketeering activity, but is an entity separate from apart from a pattern of activity which engages. In order to secure a conviction, the government must prove both the existence of an enterprise and the connected pattern of racketeering activity. Applying RICO to a legitimate as well as legitimate enterprise does not render any portion of the statute superfluous, nor does it create structural incongruities within the statute's framework. On the contrary, insulating the whole criminal experience from the prosecution under RICO is the more incongruous position. Wrapping up, lastly, D. Nothing in RICO's legislative history requires a conclusion that statute is limited in application to legitimate enterprise. In viewing the purpose of the Organized Crime Control Act of 1970 to eradicate organized crime in the United States, it cannot be said that Congress nevertheless confined the reach of the law to only narrow aspects of organized crime, and, in particular, under RICO, to only infiltrate of legitimate businesses. 632 F2D 896 reverse. White J. delivered the opinion in the court, which Berger C. J. Brennan and Marshall, Blackburn, Powell, Reinquist, and Stevens J. joined. Stewart filing a dissension. Law Dog loves you.